to, if you read the Japanese sort of guides to family law or guides to getting divorced or guides to child custody disputes, it says habeas corpus is there's the prompt remedy. If there's an unlawful seizure of your child, courts will act within 2 weeks. I think what happened in Murray's case was Murray filed for habeas corpus relief. The court did nothing, and did nothing, and did nothing, and did nothing. Then his now ex-wife filed for chain of custody. The court acted on that with incredible speed, decided to award custody to her, and then 2 days later, the court said, we're not giving you habeas corpus relief because your wife has custody now. So they clearly sort of structured it so that there was a logically consistent conclusion, just not very much logic to getting there. As I said, family court orders are generally unenforceable, which leads to kind of an odd dynamic that I think, just the slide after the next one, but I think a lot of what happens can be explained by institutional dynamics rather than law or even culture. In essence, what is in the best interest of the court system is what's in the best interests of the child. And they collide frequently, and usually the court system wins. The next slide, please. Japan has a very different judicial system from Canada. It's not unique, it's based on European models, but the important thing to understand is that to be a judge is to be a career bureaucrat. People aren't appointed to the bench after 10 or 20 years service as lawyers as they are in Canada or other jurisdictions. They enter the judiciary right after they graduate and pass the bar exam. So people may start out as sort of apprentice judges at the age of 22. They are subject to annual personnel reviews. They are subject to periodic transfers to different courts in different places. The actual criteria by which they're evaluated is not well known, but it's generally understood that docket clearing is one of those factors. So judges actually have an interest in getting cases, quote, resolved, because if they start to build up an unresolved caseload, they will get a bad personnel review. So there's this sort of institutional bias towards simple and conclusive resolutions. And this means that Japanese courts in these cases have developed sort of what I think are a set of sort of simplistic, non-public rules towards resolving custody cases. Rule number 1 is always give custody to the mother. And there's a manual that was written for family court practitioners in I think 2002, and on its chapter on criteria for resolving custody disputes, one criteria: always give custody to the mother. The exception, of course, is, well, if the father already has custody, already has possession of the child, because there is very much a possession is 9/10 of the law aspect to these cases. There is in most jurisdictions, but it's particularly strong in Japan. Another rule appears to be pretty much always give custody to the Japanese parent. And I've actually, I know that members of another country's diplomatic corps have gone to the family court in Tokyo, which hears a lot of these cases, and on an unofficial basis have been informed, well, we always give custody to the Japanese parent because the Japanese parent has a family registry, which is something we don't have in Canada, but there's a system with all families registered, marriages, divorces, parent-child relationships. And so how could you have a child that was Japanese and in Japan but didn't have a family registry? It's sort of a simplistic but easy to understand rule. I think also these rules apply because really whoever creates the status quo first usually wins. And in Japan, the majority of divorces are initiated by women, and obviously in any situation where a child has been brought back to Japan from a foreign country, the mother or whoever starts that process is going to have an advantage in terms of having created a status quo. Another simplistic rule: award visitation if both parents agree to it. This is actually the Supreme Court recently resolved a long-standing dispute over the status of visitation in Japan. There was an academic debate over whether visitation or access was a right of the parent or the right of the child, and the Supreme Court stepped in and said, well, actually it's a right of neither. Effectively, they said it's something that we get to award to parents who can agree on it. And you think, well, if you can agree on it, why are we in court? But that is actually the standard. Is if parents agree to it, the courts will award visitation. As I mentioned earlier, visitation is very often terminated if it is deemed harmful to the child, and Japanese children seem particularly amenable to harm by seeing one of their parents, because there are, as I mentioned, numerous excuses for terminating it. The current status quo is pretty much always the best for the child, even if it involves a complete change of whatever status quo existed before. The fact that 3 months ago the child was being educated in an all-English environment and living in another country and so forth, those are all ignored, and whatever situation the child is in now is the status quo that needs to be protected. Abuse is, domestic abuse is a problem in Japan, just as anywhere else. It becomes particularly ugly in child custody cases because, first of all, the definition of abuse is very broad, and really all it takes is an unsubstantiated allegation of abuse to receive a 6-month restraining order that applies not just to usually the father, the husband, but it applies to, and as between the father and the mother, but it also applies to the child. So if you want to try and keep the father away from the child, all you have to do is assert abuse, and not only will you get an order keeping him away from you, but from your child as well.